Good morning. Thank you for joining me. My name is Matthew Seidner. I'm an attorney. I work on Long Island in Westbury. My firm is called Seidner and Associates, PC. We're at 1400 Old Country Road, Suite 408 in Westbury, New York, 11590. Our phone number is 516-345-9900, and our website is www.seidner.law.com. I'd like to thank you for coming. I'm going to talk today about Medicaid, and specifically I'm going to talk about Medicaid as it relates to our senior and our aging population. My practice spends a lot of its time working with not only those that would be considered applicants, those that would receive the benefits of later life care, such as a nursing home or community Medicaid, but the children, the heirs. And I like to say that with all of the consultations that I do on a daily basis, most people fall into two groups. They're either the planners or they're the reactors. The planners tend to be the people who, in their 50s, 60s, and maybe early 70s, have spoken with somebody or learned on their own. It's often from a financial planner, a CPA, another attorney, somebody that they trust who has said to them that they should meet with an elder law attorney. The other group of people that come in tend to be people where there's an emergency. These are the people that come into my office, they're crying, they use tissues, it's, oh my God, what have I done? I didn't know any better. I also give seminars, and a lot of the times I ask people, I start a seminar and I say, raise your hand if the government came knocking at your door and told you what you should do to protect your assets and preserve your estate. And nobody raises their hand. This is more complicated than what most people think is just a matter of doing a will. In fact, I'm not even going to talk about a will today because it's so basic that it really is almost irrelevant to what we're talking about today. The theme for today is how do we move assets and how do we protect resources so that the person who needs long-term care can receive it. Statistically speaking, the AARP and some other organizations put out statistics about long-term care, and apparently 70% of us are going to need it. Why? Because we're an aging population, technology is keeping us alive longer, the quality of our life is getting better, but it's not necessarily meaning that we're healthier longer. Sure, many of us are and will be as this generation becomes more educated about what we need to do, but the people who are already in their 70s, 80s, and even 90s, they, generally speaking, are where they are, and while doctors may be able to keep them alive longer through more medications to manage chronic illnesses, they still need a lot of help. So 70% of us is a pretty scary number to me. I certainly, as a gambling person, would put myself in that category, and that leaves questions about what's going to happen. Before I talk about the specific law, what I happen to see a lot of in my practice is what I call the accidental millionaire. The accidental millionaire is the person or the couple who worked hard, they had children, they put their kids through school, they bought a house that they could afford that in their day they thought was completely over their head. They tell me it cost $40,000, but they try and tell me that back then it was a lot of money. Now they find out that the house is paid off, it's not worth $40,000 anymore, it's worth $500,000 or $600,000. Some people have outlived other people in their family and they've had insurance money paid to them. That might tack on another $250,000 or $500,000. Other people have contributed to their retirement accounts and the market has done well. It's even recovered from the recession in 08. So a lot of people, when they put pen to paper, they can't believe what they're worth. They really are shocked because they're not living the life of a millionaire. They're living the same life that they lived before they actually calculated what they have. But I get the wow a lot. I didn't know I was worth that much. Maybe I should take a vacation. And I tell them that they should. I tell them that this is absolutely something that they should do because you don't get any extra points for dying with it all, and you certainly don't get any extra points for having the government or the nursing home take it. So what we have here is most people did not purchase what's called long-term care insurance. It's a product that is supposed to cover these later in life situations. But the reality of the situation is that anybody who wants it now, who's in need of it, probably can't get it or afford it because they're too old and they already have a pre-existing condition. People who were younger, let's say people in their 30s and 40s and 50s, these are people that really should consider getting long-term care insurance, but they need to be aware that what seems like a high amount today may not actually be enough insurance by the time that they actually need it. I have a lot of people tell me that they can't believe what a nursing home costs these days, and neither can I. It seems that the nursing homes kept up with the rates of getting more expensive with colleges and universities, but not necessarily with inflation or cost of living adjustments. So it's gotten very, very expensive. The average cost of a nursing home on Long Island, and this is just a general number, but is at least $12,000 a month. So you're talking about $144,000 to $150,000 a year. That's a pretty big number. So if the people don't have insurance or sufficient insurance, now they're in a tough spot because they need the care, but they've got to make themselves eligible to receive the care, and if they have the assets, they're not eligible. And they're in a real pickle because they don't want to spend their money on the care that they need, but it might be too late. So what I'm going to get into is all stemming today from what's called the Deficit Reduction Act of 2005. Back in February, on February 8th of 2006, then President Bush signed the what I'll refer to as a DRA into law, and what it really did was it put some harsh cuts into the Medicaid program at the federal level. You see, we're running out of money in this country. For those of you who haven't watched the news or read a newspaper or been awake for the past few days or years, and we're running out of money, and as people are getting older and older and needing these benefits more and more, they're starting to realize that this is a very reality. People like me, attorneys like me, we don't worry about the macroeconomic problem here of how is this country going to continue affording this. We service our client one by one and do all that we can to protect them. But it does not skip over my brain that as a taxpayer, I'm helping fund these programs, and I see what the budgets are and how enormous they really are, and they're still insufficient, and they're definitely insufficient to meet the needs that are growing every day. So basically what President Bush tried to do and has accomplished was he made getting Medicaid more difficult for the seniors who are medically needy and have the appropriate level of resources, which is a low number. I'll discuss that later. Why did he do it? Is it because he doesn't care about seniors and wanted to lose their votes? Of course not. It was because there was a lot of Medicaid fraud. It was because there was a lot of waste, and what was happening was that people were not doing proper planning, and then when they needed the benefits or the resources, all of a sudden they'd run to see somebody like me, and we would just charge them X amount of dollars, and we'd fix all of their problems for them with the swipe of a pen. And they can't really do that as easily anymore. There's a lot that we can do for proper planning, and the way the government looks at it is proper planning is something that's truly a plan. It's something that was done far enough in advance that it's a plan. Okay, if you're speeding and you're driving and you're doing 100 miles an hour, and then you see a cop ahead and you all of a sudden jam on your brakes, that wasn't a plan to drive slow or the speed limit. That was a reaction to something coming up ahead. Well, it's the same thing with applying for Medicaid to be in a nursing home or to receive community services. If you planned far enough and were driving the speed limit all along and knew that there might be a cop up ahead waiting for you, you're safe. It's okay. That's planning. The other scenario is reacting, and it doesn't work. They made it much harder. So I'm going to explain basically 4 things were accomplished by the DRA. The good news is that because I'm talking to you today on August 2nd in 2013, this lecture is much less complicated in terms of discussing the phase-in and the timing, because between 2006 and 2011, The old laws were phased out, the new laws were phased in, and elder law attorneys really had to do more work, and people who are listening and trying to learn this, they really had to look and make a chart and look at exactly what date certain things happened so that they could figure out what to do as a result. We don't really have to do that so much anymore because everything after February 8th of 2011 is all in the same category. It doesn't matter anymore whether it's a trust, whether it's an individual. None of that matters anymore. So my life and yours is a little bit easier, but it's marginally easier. This stuff is pretty complicated. The good news is that it has a high learning curve, but once you learn it, it's like riding a bicycle. You just have to watch for changes and updates. It's something that once it clicks, and the light switch stays on, at least it did for me, and I think that it will for most people because it makes sense, and there's not a lot of room for too much interpretation in what we do. So what used to be was that if you wanted to get on Medicaid and have benefits provided to you to pay for the nursing home or to pay for community care, which again 70% of us need or are going to need, you had to figure out if you qualify. Well, you have to be medically needy, so that's a given, okay? The government is not going to pay for services that somebody doesn't really need. But the other issue is financially. The question that I ask people, especially the seniors who come in and hate the government and hate Congress and hate everything, I say, well, in all fairness, you know, if this is something that an individual is going to benefit from for the rest of their life, possibly to the tune of millions of dollars. These are actual expenses for somebody that they may receive. If they have resources, why is it the taxpayer's problem to pay for that? And that usually quiets people down, and they say, well, because I worked hard for it. And my answer to that is, playing devil's advocate, is great. So you're in a lucky position that you can afford it. But most people don't like that answer. They say, well, I don't want to afford it. I want to move my money, I want to move my assets, I want to put everything into motion so that I can have the best of both worlds. And that's what I get paid to do, and I do it every day. So I'm going to explain some of what I do and how it works for really, there's very few families, certainly in the area where we are, in the downstate New York area, but really any place where people have resources, this is something that people need to understand. But of course, I'm limited today to the federal aspect of it, and also I'm only going to talk about New York. There's different amounts and bells and whistles depending on your jurisdiction. So we'll go through that. What I'd like to talk about is when we talk about moving the assets and it not being considered a fraud and it not being considered reacting to the cop that you saw down the road or your radar detector picked up, but it's actual planning. It's coming into the office after realizing that you've got these assets and you've got these concerns. What we have to do is we have to watch out for what's called the look-back penalty. The two biggest things that President Bush, the DRA, did was it affected the look-back period. It made it go up. It made it longer. It used to be, I'm going to keep it simple because I don't really like to spend a lot of time teaching people what used to be because it's not really relevant, but as a frame of reference, it used to be 3 years. It used to be 36 months. That wasn't the case in all situations. There were exemptions for trusts. There were other things, but basically, it was a 3-year penalty, 36 months. And what that would mean is that if a person moved their assets, it didn't matter what kind of asset, a house, stock, bonds, it doesn't matter. The only assets that really were not considered were retirement assets, and those have other rules associated with them. But any assets that were transferred within 3 years caused a problem. It basically said to the government, look, here I am today trying to show you that I'm poor, and I want you to pay for my nursing home for possibly 10 or 20 years to the tune of $2 or $3 million. But just a year ago, I had $3 million of my own, and I decided to give them to give that money to my children. I decided to put some money into a trust, whatever it is. And collectively, as a taxpayer, we think that's tough to swallow. If you had that much money that recently, why are we now paying for your Medicaid? And that's pretty much what the government adopted. There was back and forth, of course, because Big agencies like the AARP, of course, want there to be no look back. They want you to be able to move your money yesterday for nursing home benefits today. That's not practical. We can't afford it as a country. But on the flip side, we do want to provide these benefits, and the reality is lawyers are able to maneuver things and make things so that a person is no different. The only other way that somebody could handle something like that is to really eviscerate all of our laws and rules about trusts and other things. That's not going to happen. So it's a game that gets played, and it has to be played right. So that's the good news is, again, once you understand it, you're okay. But what the DRA did was it extended that period from 36 months to 5 years. And that's where we are now. If we were talking between February 8th of 2006 and February 7th of 2011, we'd have to look at when assets were transferred, what the situation was, how much, and we'd have to figure out what the look-back penalty would be. We don't do that anymore. We now know that any asset that was transferred 5 years or less before somebody files their Medicaid application is a problem if it didn't have an exemption associated with it. Plain and simple, it's black and white. It's a problem, and we have to deal with it. So what I'd like to do is explain. I've mentioned the difficult part about this type of a talk is that there's really no linear way to do it. I'm trying to grow it from the roots up, but eventually we get to the point where I could take a left turn or a right turn as I speak, and I don't really have a reason why I'll choose one or the other. I just want, as you follow along, to understand that one of the big differences that we will discuss for the rest of this lecture is that there's two types of Medicaid people receive. There's the community Medicaid, which is what most people associate with getting services from, for instance, the visiting nurse service. That's where the person comes to the home. That's where somebody gets all the help that they want, but they're in their own home. And then the major category of other care through Medicaid is the institutional or the nursing home. The rules are they're just polar opposites. The look-back penalty, this 5 years that we're talking about now, only applies to institutional. It doesn't apply to community. I don't know why. I speculate. Those of us in the business talk about it, and we think, obviously, that there's reasons. It's interesting. I think it's interesting because the federal government gives states the option of what they want to do. In other words, whether states want to impose a penalty for community Medicaid. In 2006 and in 2010, New York said no. I think that's a little bit surprising, but it is what it is. If anybody wants to look at the source of the Fed code, it's going to be at 42 U.S.C. Section 139 P, C, 1C, Roman numeral 2. So New York has never taken that road, and maybe in the future it will. But for right now, that bit of information is pivotal because I have to counsel my clients on what to do if they've waited too long to transfer assets, because I can still move their assets and I can still plan for them and still get them community Medicaid. And most people say that's incredible. The people are so happy because most people want to be at home if they can. And if they can be at home and have this enormous amount of care essentially for free with no look-back penalty, most people jump at it. I can tell you it's the morning right now, and it has not been more than 12 hours since I signed up my latest person to do exactly that. So this is an everyday occurrence for those of us in this business. There are always people who want to do that. So the way that we look at it is, I'm not going to go through each and everything, but there are if we're going to talk now about the institutional, because we're going to talk about how to calculate a penalty, okay? And there are exceptions to this, which I'll get to, but generally speaking, a penalty period is just a waiting period. It really means that if somebody who wants to be on Medicaid transferred assets, they have to basically pay their own money, or at least not expect to send a bill to the taxpayer for a certain period of time. How do you calculate the penalty? Well, it's as arbitrary as anything else. You have to take the numbers that the government gives, and you have to take the amount that was transferred, and you have to do some division. It really isn't rocket science, but it is something that the attorney has to be able to look at. Why? Because we have to look at what the penalty is. We have to look at the lesser evil here. Is the lesser evil to do something that gets the penalty clock ticking while the client has home services and other care that is not exactly what they would have wanted? Or do we bite the bullet and say, well, the amount that was transferred was so small, who cares? And the example would be if somebody transferred $1 million to their children, for instance, that is something that what you would do is you would look to the county where the person lives and what they transferred, and you would make a calculation. Let's say you were on Long Island and you transferred that money. You would divide it by approximately $12,000. Let's say you were in New York City, it would be more like $11,000. I'm not going to give the exact numbers, they change every year. But it's about $11,000 for the city and $12,000 for Long Island. What you do is you divide, and that will give you a number. And that number will be in months. So to keep the math simple, if somebody was in Nassau County and transferred $120,000 to their son or daughter and then wanted to apply for Medicaid within 5 years of making that transfer, you're going to take $120,000, you're going to divide it by the $12,000 amount that Nassau, and there's going to be a 10-month penalty. There's going to be 10 months worth of time that the taxpayer's not footing the bill. And this is a big deal because, as I'm going to explain later, there's an inherent catch-22 because, let me plant the seed now and then you'll see how it grows later. For somebody to be eligible for Medicaid, they have to have less than, we're going to say, $14,400 for an individual. So they have to be that poor. They can't have assets worth more than that. However, if they've transferred money and have a penalty that they need to pay, where are they supposed to get the money to pay the penalty? If they're eligible, they might not have the money. It really is a catch-22. And I have seen situations, all of my colleagues for instance, at the Nassau County Bar Association, where we have the Medicaid luncheons, we've all seen these situations where there's very little that can be done. Hardship applications can be filed, but now you're talking about fair hearings and litigation over the benefits. But it is a problem, and I'll explain a little bit more later. The big problem that these people have now that I just referred to is the second thing that the DRA changed, which is when the penalty starts. People who talk about something that maybe you've heard of, it's called the rule of halves. These are people that are talking about pre-DRA changes. It used to be easy. It really was. You used to be able to look at what was transferred, divide it by that number, and you could get an idea of how long the penalty was, and you could wait it out because the transfer itself was the triggering point of when the penalty started. So if you transferred something 5 years ago or 4 years ago, you would look at what you transferred, you would be able to do a calculation based upon the amount and the time, and you could still wait out that transfer and then apply for the nursing home. Now it's completely different. Now the penalty doesn't start until you have your application done for the nursing home. So if you've done anything within 5 years and you thought that you could wait it out, I'll give you a simple example. Let's say 3 years ago, 3 years before Grandma wants to apply for Medicaid, she didn't have much, but she did have something that she wanted to give away, and she had $36,000, and she gave that to her grandson because he got into Harvard, and this is a big deal, and they definitely wanted to make sure he could afford to go. That's great. It's a beautiful thing. We all want to do it. The problem is it's within 5 years, and it was $36,000. If Grandma lived in Nassau County, they're going to divide that by 12, and that's going to be a 3-month penalty. Now, let's say Grandma gave away 3-month penalty worth of money to her grandson, which is a very nice thing to do. Under the old rule, All Grandma had to do was wait 3 months before she would apply for Medicaid, and she'd be good. She used up the penalty. It was within 5 years. She gave up an amount. She waited 3 more months, and she's good to go. Okay, she can make her application. Now you can't. If that penalty was done within 5 years, the clock starts running when the application is made. In other words, the first 3 months of nursing home are supposed to be paid for by Grandma. Now, Grandma might be eligible because that might have been her last $36,000, so she's poor enough. She might be medically needy, so she fits the bill, but she's out of money. Where is she supposed to get the $36,000? It's spent. Harvard's not giving it back. Harvard used it. So what does Grandma do? Grandma's in a tough situation. And we'll explain how, but Grandma's in a tough situation. That's why the planning needs to be done with the attorney. So the way the rule works for those who are looking for legalese is that there's the penalty begins running on the later of 2 events. The first one is the date the assets are transferred, and it's the or that applies to most people. It's quote, and then I'll abbreviate, but it's the date on which the individual is eligible for Medicaid and would otherwise be receiving institutional care based on an approved application for such care, but for, underscore it. It's the but for that's the problem, the application of the penalty period. So that's what really happens. It's that most people will be admitted to a nursing home and will apply for Medicaid, and they need to be financially eligible, and they are, but for the transfers. They have this penalty that they now need to pay, okay? So it's a difficult situation. Most of the time, the first situation really only has to do in a situation where somebody's already on Medicaid, and then they receive a benefit. Let's say they're in a nursing home, and then a lawsuit pays out that they won, or sometimes an inheritance comes through, and they're already on Medicaid, and they transfer it out. It's still a problem, but it's much less common than the person who needs to go into a nursing home, has transferred their assets, and is medically needy. So anything that happened after February 8th of 2006 regarding a transfer is going to be governed by the 5-year look-back. And the rub comes that now we have this situation. So the law is now more complicated in this area. What does it really mean? It means that every Medicaid application for a nursing home needs 2 applications. And try and visualize this, because this is how it works. But there's a first application. The first application is going to be when somebody's admitted to a nursing home and they're, quote, otherwise eligible to receive the Medicaid, meaning that the resources are under the, let's say, the $14,400, and the person is medically needy. But now where we stand? We have that but-for clause. If they gave away assets, we have an issue, because what's going to happen is there's going to be a denial. It's coming. We attorneys, we know that. We're expecting a denial. We don't tell our client they're going to be accepted and then tell them we messed up and now what are we going to do? We know there's going to be a denial. So what we have to do is, in a step 1, we have to determine if they're otherwise eligible. We have to look at their transfers and know what to tell our clients. If they come in and they tell us, I don't know, well, then we don't know. But if they come in and they tell us, this is what we did, this is where the money went, this is what happened to the house, this is what happened to the stocks and bond funds at Fidelity, wherever, we can tell them, we can give them a general idea of what their penalty is going to be right there in the office. We can simply calculate it for them. But we're still going to do an application, but the problem is that they're going to be rejected. The application is going to be denied. So what we have to do is, once we get the denial, now they have the penalty period kick off. Okay? If you're still with me, it's because they're under the allowable resource limit, and it's because they're medically needy, and but for that transfer, their application would have been approved. Well, it wasn't. It was denied, so they have a penalty. Now the penalty starts running. And what's going to happen is, after the penalty runs out, they do application number 2. And application number 2 will be approved as long as nothing else went on between application number 1 and application number 2 that caused a new problem, because DSS, Department of Social Services, that does all of these analyses, they're looking for the sum total, okay, and they're going to look to what's happened, and they will find it, because anything attached to the Social Security number eventually is going to show up, and I find it sooner rather than later. So there are exceptions to the transfer penalty, and this is so important. The legislature and voters, obviously, who put in our elected officials, obviously this is a segment of society that wants to get benefits, and there's exceptions to the penalty period for transfers that were made within the look-back period. And I don't really want to get into the pre-DRA changes simply because what's the point? We don't have enough time. But what I can do is tell you right now that when somebody comes in and is in that, I call it that delta period, that period where they're in trouble. They're not the first group of people that came and did advanced planning. They're the people who are reacting to something happening right now. Usually somebody who went from the hospital to rehabilitation. They're getting their 100-day Medicare coverage, but they can't really go home, or they can go home, but they don't know what type of care they need. It's usually people who are trying to figure out how to fix a problem that's present right now. The first thing that we look for is what exemptions are there. The biggest, highlight, asterisk one is the spousal transfer. You get essentially what I tell people is a get-out-of-jail-free card, because you can transfer assets to a spouse. You can transfer them. The typical situation is that, I'll pick on men because I'm one, and demographically what I'm saying is true. We don't live as long and we get sicker faster. So unfortunately for me and those guys that are listening, it's the women that wind up giving up their get-out-of-jail-free card, because the man uses it first. It's usually the man who's older and sicker and who's going to live a shorter lifetime than the woman, and what happens is something went wrong and now we need to get everything out of his name. We need to put it all into the wife's name. It doesn't matter if it's 5 minutes before a nursing home or institutional application is going to be filed. We don't care, because it's an exempt transfer. I'll explain how the wife's now got a problem, because her train may be pulling into the station in the future, and this is really just kicking the can down the road. But when I tell most people who come in that they're okay, I can actually fix this now. I can get them, out of the emergency room, okay, and then we'll do step 2, which is deal with the wife's problem that she now has, that she's loaded up with assets, and she does not have a get-out-of-jail-free card. They're very happy. This is when the tears start flowing. This is when they try and hug me, and it's good, because they didn't understand that they had this option. So that's the big one. We want to see if we can move the money to a spouse. Other exceptions are if somebody has a child who is blind or disabled, that assets can go directly to the child or to a supplemental needs trust that will benefit the child. There are rules about that, what kind of trust it is, how it's funded, and the age of the person. But this is not a trust seminar, so I'm going to just let you know that there are rules about that, and an attorney needs to know what they are. And one other point that I want to make on this is this is more, again, of an asterisk, because this is something that experienced elder lawyers are already doing. But there's a rule, as I just told you, that when one spouse kicks over all the assets to the other, they've now used their get-out-of-jail-free card, they're able to get all these benefits without having done proper planning. There's another issue, which is that now if the receiving spouse is loaded with assets, technically speaking, I should say legally speaking, there's a maximum amount of money per month that what's called the community or the non-applicant spouse can have. So they're only allowed to get in X amount of dollars per month, and they're only allowed to have a grand sum total of X amount in value. So the numbers, which are not numbers that are very important, but you're generally allowed to have right now the community spouse just under $3,000 a month in income in 2013. It's around $2,900, and you're allowed to have assets of around $116,000. Again, these are numbers that move, but the real thing is, and I say is, so what? It doesn't really matter, because if you're the community spouse, and the home is a different issue, I'll explain the homestead. If you're somebody who has that money coming in, or more than that money coming in, the way the law looks at it is, well, you have a duty to support your spouse. You got married, you have all these benefits for being married. Well, one of the downsides is you have to support your spouse, I guess, and you're supposed to do that. But what was happening, or the government didn't want to see happen, is people getting a divorce simply to avoid that obligation. Because if the assets were transferred to a spouse as part of the exception, the last thing you want is that spouse to now go file for divorce and have to break up a marriage, a family, because of Medicaid laws. It's obscene, it's offensive. So what happened is you can now do what's called a spousal refusal, and it really says, I am the community spouse, and I do have these assets, I just don't want to spend them on my spouse. And it seems like it's a strange thing to sign. It's not something that probably sits well with most people, but it's something that unfortunately attorneys do have them sign, because it keeps them from having to do the alternative. And then there's the flip side to this, which is the government and the courts first allow you to do this, but now the courts are actually, at times, depending on what county and depending on how aggressive and the amounts that were transferred, but they are now pursuing support, that you can pursue this. The agency can actually sue for spousal support. So it's something that you have to tell your clients it could happen. It has not happened to any of my clients yet, or not that they've told me. But I do let people know that when they do the spousal refusal, they're not quite out of the woods just yet. They're probably out of the woods, but it's not a sure thing. So that's just something that I want to state. Once you use a spousal exemption, you do have this, what are the resources and income left? And then you get around that by doing the spousal refusal. But keep in mind, the spousal refusal may be challenged by the agency suing for support. So I assume you're having fun so far. And what I'm going to do is talk a little bit more about some of the exemptions. So there's the homestead exemption, which can be transferred penalty-free, obviously to a spouse, but as I mentioned, it can also go to a child who's under the age of 21, or an adult child who's blind or disabled. And there's another provision where it's called the caregiver child exception, where if the child lived with the applicant for 2 years or more, the prior 2 years or more, and has been taking care of them, it can be transferred to them. The logic is, well, this person kept them out of a nursing home, this person provided care, so that exception is there. How do they prove who lived where and what they really did? I don't know. I just know that if somebody's willing to file under that exemption, that they did it, and they're telling me something that I can put my name behind, then I don't have a problem with it. I certainly have no way of knowing whether they were really there for the past 2 years, and if so, whether they were really providing care. So I'm not going to get too much more into that. What we have here is, I told you earlier I was planting a little seed about the catch-22 of you transfer money to make yourself Medicaid eligible. You're otherwise able to get in and receive the care because you're medically needed, but now you've got this penalty. So the problem you have is, let me make it a little bit more confusing. Let's say the person who you gave the money to gives it all back. It wasn't Harvard tuition, but it was the grandson, and grandson says, oh, well, I hate giving the money back, but I'm obviously going to give the money back since now it turns out you need it. All that really does is it avoids the penalty, but we've still got the same problem, because if the money was given back and the penalty is away, well, now they're not otherwise eligible because now they have too many resources. So as you can see, it's just this cycle of what do you do? Well, for most people, getting the money back is a tough thing because it's spent or they really can't get it back. Well, you do have a problem. You definitely have a problem. The law will allow what's called a hardship application to be filed, and there are situations where the benefits can still be approved even though the penalty is not something that the applicant can afford. But as I'll explain, there's a pretty rigid guidelines. One of my mentors, who's retired now, is one of the big names in this field, has told me your violin better be pretty good. Okay, your violin playing, it better be pretty good. So what you have to show is that, if you can, is under the DRA section 6011D, which is also under federal code, it's 42 USC 1396 PE2, you have to show that if Medicaid was to be denied and the denial sustained, that the basically health or life is endangered, and that food, clothing, shelter, and other necessities of life will be denied. So basically, this person is going to die on the street. Is really what you have to show. And you also have to show that your best efforts have been made to have the assets returned. You can't just say, well, I gave it and I don't want to give it back, or I think they spent it. You have to prove that you used your best efforts to get that money back, and you may or may not be able to. So what's very clear is that if the hardship is that the individual spouse's ability to maintain the pre-existing lifestyle is something that will suffer, that doesn't qualify. You have to really be in bad shape to do this. Now, there's a lot of things that people do to spend the money in ways that are considered legitimate, and they get the money out of the applicant's name, but they require a good amount of work, and a lawyer will be able to explain these to the client, but let me explain some of them now. One of them is the long-term care insurance to cover the penalty period. As I mentioned, many clients are just going to be denied the coverage because they have pre-existing medical conditions and the cost is so prohibitive. But again, the cost is going to be less than the nursing home, so that's not what's such a killer. What's a killer is their age and their pre-existing medical conditions. So New York does have a special program. New York is one of very few states that has a program, and I can give a general explanation of it, but it's not meant to be thorough. It's just that there's certain ways that there are special policies that are what are called partnership policies, and they will allow someone to get a small amount of coverage basically to cover a penalty period, and there's other things that need to be done, such as income that's coming in to that person's household needs to be contributed. So it's not meant to be one of these plans where you can just take advantage, get the plan, and then still think that you're going to keep collecting all of your income and live the same way you were. So that's one example. Another example is prepaying for necessary expenses. So you can prepay, and it just could be for any period of time, really. It could be for months, it could be for years, but your bills, they could be your cable bills, your phone, the client's phone bills. They just have to be at market value, otherwise they're going to be considered a transfer. That was a gift. You can prepay for your funeral. Here's a big one, you can pay off mortgages or other debt. But another one that's getting more and more common, I don't know if it's because it's difficult to enforce or if it's just because it's becoming more legitimate, but there's what are called caregiver agreements or personal services contracts, which are literally written agreements between the applicant who gives a lump sum of money to a family member or somebody that would otherwise not be under the exemption. And what they do is they agree to services, and the services could be financial management, they could be rendering some sort of health care, they could be whatever it is. But what I would tell people is expect scrutiny on those agreements, because again, much like the spousal refusal is almost a straw transaction, and now they're starting to crack down on them and sue for spousal support. This is one of the things that I think is next on the agenda, because obviously somebody can say that they're going to pay fair market value and start giving money to their children, and this one's managing their finances and making $20,000. This one's doing their travel to and from doctors for $5,000. And as you add these things up, they get pretty expensive, and they're going to be scrutinized because it has the potential for fraud. Another thing you could do is, this is not something that I do very much, but you can buy the applicant can buy a life estate in another person's home, which gives them the right to live there. So again, prepaying rent for a long period of time, buying a life estate in another person's home, it just has to be legitimate. And the way you can tell whether something is legitimate is by looking at market value and actuarial tables. There's something else that can be done. Let's say you're in a situation where you have this amount of money and you haven't given it away, but you need to give it away in order to become eligible. Annuities is another huge thing that the DRA, another one of the four things that the DRA affected, because annuities, try and picture this if you can. Somebody has $500,000. They can't get into a nursing home, obviously, under Medicaid with that money. So now, they haven't given it away. They're sitting there with this money right now. What do? Well, if they do the calculation and they give away approximately half, this is rule of halves under the old rule, but let's say they do the calculation and they realize, well, we've got about a 24-month period of penalties. We divide it by about 10,000. I'm using $250,000, but it's a little bit off. We've got a 2-year penalty period, okay, because $250,000 divided by about 10,000 is about 24. And they say, well, that's fine. I'm going to give the other half wherever I want to give it. I'm going to give it to children. I'm going to put it into an irrevocable trust. Wherever I'm going to put it, that money's safe. They're allowed to do that. But what do we do with the other money? If we give it someplace where it's penalized, we're back to a penalty, and what if we're in a situation where we can't get it back, like it went to Harvard for tuition? Well, the annuity fixes that. The annuity is a place where the money could go. It's technically out of the person's hands, but unlike Harvard, the annuity is going to give the money back. And the way it's structured is that the way the annuity gives the money back, it's over a certain period of time. And of course, the lawyers and the salesman that sells the financial product, they work so it is perfectly aligned, so that every single month the annuity is spitting off a certain amount of money, which just so happens to pay that month's nursing home bill. And that annuity lasts, guess how long before it's depleted? 24 months. So that's something that is able to be done. But there are, again, to avoid fraud, there's rules about the annuities. First of all, it needs to be an irrevocable annuity. Again, if you give your money to your grandson's tuition to Harvard, that's irrevocable. You're not going to get that money back. Harvard's going to say, I don't think so. Well, if you're giving it into an annuity, it still has to be irrevocable. And it also has to be actuarially sound. It means that the life expectancy of the person is an important factor. You can accelerate, but you can't go past death. So that's why you're able to structure this so that it pays out on a monthly basis the way you need to cover your penalty while the money is still technically out of your hands because it's irrevocable. So hopefully you're with me. You've given away money, which is fine, and then your penalty money, even though it's not in your hands, you're able to get it back and structure how and when you get it back. And the payments have to be immediate, and they can't be deferred. There can't be a lump sum balloon payment at the end. In other words, it has to work just so. And probably the biggest issue is that for it to qualify, there's a payback provision to the state, that the state must be the primary beneficiary of the annuity. Now, what does that mean? Because these annuities are complicated, and clearly they are, we figured out another thing that could be done, and these are promissory notes. Promissory notes are what they say they are. They're promissory notes. It's the same thing as an annuity, except it's much less formal, and you don't need to give money to the state as a primary beneficiary. You can basically, in that $500,000 scenario that I gave, you give the $500,000, $250,000 as a gift, the other half that would have gone to an annuity, you can still give it to the same person. But they give you paperwork, and the paperwork is an agreement to pay you back over a certain period of time. And again, the same magic occurs. Where does that money go? To the nursing home. Okay? It pays the penalty. But they never give you too much, because if they do, and you're over your resource limit, that creates a different problem. So it's always going to jive. It's always going to make, it's going to balance. The numbers have to balance. There's a little bit of wiggle room. I never tell a client to make sure that they have $14,400 in their account, but no more, because I don't want to sit and calculate what happens if they got a refund of a fee that put them $10 over. Because the computers that look at these things, they don't have a sense of humor. They don't think that's very funny. And they don't really make a distinction between $10 over the limit and $10,000 over the limit. So I don't gamble right at the line in the sand. One other thing that I like to point out is what I would call the fourth thing that the DRA did. It's the least important, I think, is they put a cap on how much equity somebody can have in their house before qualifying for Medicaid. Before I explain why that's important, think about the situation. Common sense. Somebody wants to apply for community Medicaid. Therefore, they live in the community. Therefore, they're most likely to have a house. A house is most likely worth more than $14,400. So, obviously, that's an issue, isn't it? No, it's not an issue. If you're getting community services, you can have that house as long as the equity in it is not more than $750,000. Here's the problem. They'll approve you. They'll say yes to your client. What the client needs to understand is by allowing that, if the house stays in their name and was not transferred into a trust, for instance, and the trust granting the applicant a life estate to live in, Medicaid is going to put a lien on the house for the services. Medicaid is only allowed to recover based upon an estate's assets. Okay? So it's a bit of a trick gift. I look at it more as a loan. We'll approve, the agency will approve the person, and they will get the benefits. But when they die, Medicaid is putting a Medicaid lien on the premises. So I really do try and explain to people that you really do have to go through the expense of doing the trust, the Medicaid qualifying irrevocable trust. You really have to do it because you got to put the house somewhere. The house is still someplace you can live in with a life estate, but now when you die, remember, the transfer is exempt. It's not going to matter if you're getting community Medicaid. All it does is add a little bit more to your fee to hire a lawyer up front to do it. You have to do the trust, you have to do the deed. But when all is said and done, you're still going to be able to qualify for your property tax benefits, STAR, Enhanced STAR, veterans. You just have to go file it at the county clerk's office. Life estates under these trusts qualify. So there's no reason not to do it. And what people, I think, don't learn from other professionals who are non-lawyers is that qualifying for Medicaid is one thing. Making sure that they don't get it back later is a whole other thing. And I have to know both of those things to counsel, because I don't want to get a call in 5 or 10 years and somebody says, well, they just put a big lien on my house. Why didn't we do something about that? I always make sure that that's something that we do. So there's on the equity in the home, assuming it's not transferred to get onto Medicaid, and somebody keeps it, which to me is not the wisest thing to do, but let's say they do it. There's a $750,000 cap on how much equity can be in the house. Why? Because the government says, we are going to let you live in your house and get this benefit, and we are going to attach it later, if it wasn't moved out of your name, into a trust wherein you retained a life estate. But if your house is worth has equity of more than $750,000, sorry, you're still getting a little too rich for our taste, and we're going to have a problem with that. So what that's meant to do is force the person to either sell the house and pay for some of their own services with the profits. But since nobody wants to do that, there's something else that everybody considers doing. It's a reverse mortgage. A reverse mortgage is a product that will allow a senior to borrow against the equity in their house. It works for a lot of people. For a lot of people, it's the only thing that can keep them in their house because they don't have the income they used to have, but they have a lot of the expenses that they used to have. So the reverse mortgage for a lot of people works, but it also is something that doesn't work for everybody. It's not a good short-term way to borrow money. It has high closing costs, and because it's a negatively amortizing loan, meaning that it grows over time because you're not making payments, so the interest is growing and compounding, as opposed to a normal amortizing loan, which is getting smaller as you pay it off. These are things that really can, if you take it at a young age and borrow a lot of money, there can be nothing left by the time that it's time to deal with settling the estate. So it's not something that should be considered lightly. And again, I don't really see it as being that crucial in the first place because most people don't keep the house in their name because an experienced lawyer will say, getting the services is only half the battle. They're going to get the money back from you when you die because the house is still in your estate. Get it out of your estate. That's what we do. So that's another thing that changed in the DRA. We're almost at the end here, just a couple more minutes. What I would want to be a takeaway idea is that try and explain to your clients that Medicare and their private health insurance is not providing what we're talking about today. People think it does. It does not. Not even close. People think, well, I'm on Medicare, I'll go into the nursing home. That is not what is correct. It is actually very, very wrong to think that you can rely on these services. You may feel that you paid into a system or that you have insurance or other products. It's not going to help you. It's a very black and white field. You're either going to private pay at the public rate, or Medicaid is going to pay at the Medicaid rate, which is lower. It is a lower number. The government pays the nursing homes less than a private person would. So what you want to do is you want to make sure that when someone comes in your door, whether they're planning or in an emergency situation, first assess what's the number we're talking about that's causing the problem. 2, what are the exceptions to transferring it, if any? 3, how can we minimize the damage if the exceptions don't cover the whole thing or any of it? How can we minimize the damage? Is this somebody that can stay at home? Okay, as I explained to you before, let's say somebody uses a spousal exception and transfers the money out. That's great. What about the person who's now loaded? Even if they do the spousal refusal, and even if they never get sued for spousal support, what happens when they find that they're one of the 70% of people who are going to need long-term care, even if it's 5 years later, 8 years later? Well, it's pretty important that as the attorney you step in and take care of that what if, because we would consider it bordering malpractice not to. We will have somebody go to step 2 and we will say, you now need to put your assets into a place and let's hope that you wait out the 5-year look back. If you don't, that's not in our hands. But what's known is that if you do nothing, you have a real problem. So hopefully people will be convinced by again, other professionals to do planning that's timely. It's not that there's nothing that can be done if they come in and it's considered very late in the game, but we have so many more options when they come in early. So if there are no questions, I think that That's about as deep into Medicaid as I want to get today. Another time we can talk about what happens with other types of supplemental needs trusts and pooled income trusts, and talk more about the provisions of the Medicaid qualifying irrevocable trusts a little bit deeper, but not today. Yeah.
The transfers
Yeah.
themselves. What if it was like a legitimate gift, like you gave the example, grandma gave money to the grandson for Harvard. It was a gift. It was a legitimate gift. It doesn't matter why the transfer, as long as it was a transfer within.
No, it doesn't matter. Okay. Sometimes, in very rare situations, if the gift can be shown to have not been for any reason related to qualifying for Medicaid, they might approve it. Let's say every single year for the past 20 years, the applicant gave $20,000 a year to the son. Every year. And now there's a Medicaid application. You can make an argument in a fair hearing that that's a pattern that existed a long time ago. But doing it all of a sudden, I understand your question, which is, well, this is when grandson got into Harvard. I didn't plan it this way. What was I supposed to do? Tell him to wait, him or her, to wait until I was out of a look-back penalty phase? No way. And the government says, that's great, we understand. But it is what it is. Because you did have the money, you did transfer it, and it was not an exemption. So you're going to have your penalty. And unfortunately, it doesn't really make anything worse, because if the transfer hadn't been made, what do? Because now you're ineligible. You had to get rid of the money somehow. So this stuff does, like I say, start to congeal. And as I said at the beginning, it has a high learning curve, but then it just clicks. Almost any scenario that you throw at me, as long as I have a calculator and a pen and paper, I can pretty much figure out what's going to happen, because there's just not that much wiggle room. Where there's wiggle room is when you have these fair hearings. I had something recently where a law firm had not done a great job on something, and they came to me to handle the fair hearing, and we were very successful in the fair hearing because we were able to show, we had to go down to Brooklyn and sit with an administrative law judge, and it was opposed by Department of Social Services attorney, but we had to show what was really going on, and we had to meet the burden of proof that was necessary to approve or continue the application. It had been denied. We got a continuation, which is what we wanted. But these rules are very rigid. I had somebody who was 101 come in because she was, I guess, a contingent beneficiary on a CD that a sister had, and the others had now passed away. She outlived everybody, and they sent her a notice that she was off Medicaid. So there are situations that have to be dealt with. But the type you're asking about, it was just a gift, well, that's exactly what they're looking for. Everything's just a gift unless it's an exemption. And the exemptions are this big, the category of gifts is this big. Is that, yeah?
When taking out long-term care insurance, what is I know some policies have a maximum benefit. Mm-hmm. What do you think is an acceptable maximum benefit?
I have no idea, because I had somebody come in who had a military policy, and this gentleman really was convinced that he was good to go. And I said, listen, I hope you're right, but let's figure this out. We called the provider on the spot. The whole family was in the room, so there were 4 or 5 people, and me and probably my paralegal were sitting there. We were in the room and we called, and I don't remember the exact numbers because this was a while ago, but generally I think what happened in that case was this gentleman believed that, let's say he had $1 million benefit for nursing home. That's great. They had, but it was like winning the lotto. It's on a payout plan. And let's say the payout plan was $50,000 a year for 20 years. Well, that might have seemed like a lot of money when the policy went into effect in let's say, the 60s, but it's 50 years later. Okay, he was smart enough to contribute way back when he was coming out of the service, and $1 million probably, look, he didn't expect to live this long, first of all, and who thought that $1 million wouldn't be enough to pay for a nursing home 40 or 50 years ago? I don't know. I just don't know. That's why I don't like the policies all that much. I really don't think they're that great. And I also think that to get the type of coverage you would need to sleep at night at your age, it's going to cost you so much money cumulatively over the course of time that who knows what was the worst situation. Maybe paying the penalty is better. Who knows what the penalty is going to be when you or somebody you care about might need it. The only thing that I know that I'd put my money on is the penalty time is going up, not down, and it's not going to stay the same. I bet that we're going to go from, again, I have no inside knowledge, but I think it's going to go from 5. They're going to probably try and get to 10, but probably have to stop at 7 along the way, something like that, because they can't just pull the rug out that quickly. And even when they changed it for the DRA, it was a phase-in over 5 years. So there are a lot of people rushing to attorneys' offices when that law passed to have a 3-year look back. Hope that answers the question, because the real answer is I have no idea. Any others?
Do you do planning?
I don't do financial planning. I don't touch it. I mean, not for a client anyway. I don't know what to tell them to do with their money. I, of course, have people ask me, and I can tell them, you might want to go to this type of financial institution or this bank or this, but I don't get involved in that because it can only come back to bite me. It's not something that I know. So, they have to go manage their own money. But that's why the financial planners are people who often send someone to me, because the financial planner is not really doing their job if all they do is make the person money. That's fantastic. Make lots and lots of money. If you wind up spending it all in the end...
No, I'm not talking about that.
Yeah.
I'm talking about now you were suggesting that to move money into either annuity, or reverse mortgage or stuff like that in order to be within the legit...
The reverse mortgage is just a way to lower the equity in your house.
I know.
And moving it into an annuity is not an investment vehicle. It's just a way to get the money legally out of your hands so that you're eligible for Medicaid. And since there's a penalty, it's a way of guaranteeing that the money will be there to pay the penalty, which is a comparison to if you gifted it to the university for tuition, because they're not going to give it back.
So what would you suggest? Going to... a person needs to know how to maneuver in order to, when you need to get to that point, to actually be okay and not to freak out that...
Yeah, the annuity only comes into play...
No, first of all, would you suggest to go to a financial planner and then be in contact with you in order to see what your situation?
It's essential that you have an attorney, a financial planner, and an accountant.
Attorney for
the elder law aspects, okay? Because none of us can do what the other one can do properly. The accountant is going to have to deal with the tax issues and the structure, and let's say you have the trust is generating income. What are you going to do? You don't want to pay trust tax rates, you want to pay individual rates. So you need your accountant to know what's going on. You need your financial planner to manage the money, okay? The money needs to be properly handled, but then you need the lawyer to make all the documents.
The money is not actual cash in a bank, but as in other assets, real estate assets.
It still goes in. You would still put your house into the trust. Okay. You would still put it in and then have the applicant take a life estate. You still want to get it out because, first of all, forget the exemption that the DRA changed in this $750,000 limit. Who cares? You don't want it in your estate. You don't want Medicaid to later claw back the money that it gave to you.
That's what I'm talking about.
You don't want that.
Yeah.
So.
But for example, you were talking about the $750,000 worth
Equity cap.
So if you live in something that it's more than that, and it's in your estate, right? I mean your fund or estate, right?
Your net worth. It's part of your net worth.
No, you're not showing it on your name, but
you have. How are you going to show it? It's got to be in the name of the owner. It's on the land records.
Yes, I know, but if you move all of it into some kind of
the trust
fund, trust of the sort, is it still on your name?
No, it's in the trust's name. So if I was doing it, mine would be the Matthew Seidner 2013 Irrevocable Trust, and I would name somebody that I trust to be my trustee, and that person would now technically have management over the house. I would be a beneficiary during my lifetime. I would have a life estate so I could live in it and do whatever I want with the house so long as I'm alive. But then I'd name a beneficiary, somebody that would automatically receive the house, which kind of is a great way to come in full circle. It means you don't need a will for the house or to worry about intestate succession laws. Remember I told you wills are just, I probably won't even say the word today. Well, I'm closing saying that's why I didn't have to say the word today. Because once it's out of your estate, we don't care. It just doesn't matter. We'll do a pour-over will so that everything goes into the trust.
So you're saying that if it's already in an estate, in such a trust, they look at you as a needy?
Depends on the trust. It's got to be a Medicaid qualifying trust. If it's in a revocable trust, it's the same as if it's in your name, because you can just take it back at any time. For Medicaid, it has to be irrevocable.
Oh, I see.
So that's the key. The one thing that people don't like is they hate that word irrevocable, because they think, I lose control, I lose control. I have to go talk to my trustee for this, that, and the other thing. What if the trustee wants to sell my house and put me out on the street? Well, I don't know. I have had litigation where I have had trustees removed. I'm not going to say that bad things don't happen, because I've had to do it. But generally speaking, you're picking a family member or two, and it's somebody that's going to do right by you. So it's as if you're making up all of the decisions yourself, but you're going through the act of now saying to the trustee, I don't want to live here anymore. I want you to sell my house so I can downsize and take the money and move to Florida and buy a condo. And with the profit, I want you to invest it with Merrill Lynch. Go call my financial planner. Instead of you doing it, your trustee now does it. But that's really, again, more of a this could be another hour dealing with the powers in the trusts. So I guess I will do one of those. Good?
It's like never-ending circles.
But once you know it, you know it.
Well,
that's
you
what's
know
so
it,
nice. Honestly, it's not the type of law that you always have to see what the latest case said to understand, what the trend is or how there's been interpreted.
As a person, to know what to do, that's the problem.
Gotta come see me. Gotta come see me. Any other questions?
Well, the state law is vastly different.
I don't know. That's an open-ended question.
Federal,
No, I can't say.
It all, but
I can't say. The state laws are different. Vastly, I don't know, and I don't go there. I can tell you I have looked at Connecticut and New Jersey and Florida at times for certain reasons. Those are just three that come to the top of my mind. But I'm not admitted in those jurisdictions, and again, we look here to where the person is domiciled. I don't care if they have property in other places. In fact, the person that retained last night has exactly that situation. They have 3 different properties in 3 different states. But we care about where their residence is, where they're domiciled for Medicaid purposes. That's the county that will review it. Does that make sense?
And that matters.
That matters.
There is no, for instance, they moved from New York to New Jersey, and now they're going to apply for Medicaid.
Well, they would have to do a new application. They would, because this is a federal program that's meted out by the states, so they will have to do a new application there. So, is that good? Mm-hmm. Good?
Good.
Thank you guys for coming.
Thank you.
I appreciate it.
Card?
Yeah.